Hi, my name is Henry Casale,
I'm Dan Mulholland.
and we're partners with the law firm Horty Springer and Mattern, and we want to welcome you to 2026. It looks like it's going to be quite a year for federal administrative and judicial enforcement of the federal fraud and abuse laws and attempts by various federal healthcare programs to recoup money that you may have already been paid. So we want to talk to you about some things that we see on the horizon for this year and wanted to make sure you are aware of them.
Yeah, the first thing is a pretty big development that happened on January 8th, and that's when the administration announced that there would be a brand new Department of Justice National Fraud Enforcement Division, which will focus specifically on fraud generally, but in particular, it's going to have a lot of focus on healthcare fraud. This was the result of some allegations of widespread beneficiary fraud, as well as fraudulent organizations that were set up to become participating providers in Medicare and Medicaid. And it's gotten a lot of publicity nationally. But this is very interesting because the Department of Justice has 11 divisions by statute. So what they had to do is sideline the tax division. I guess they'll deal with the boys in the IRS for that. And this fraud division is going to focus specifically on fraud. And there's an assistant attorney general who's in charge of the fraud division to look at investigations, enforcement priorities, and also strategic policy guidance to the attorney general. That's going to be a big issue, don't you think, Henry?
Yes, and I think that what we're seeing, especially given the interest that the government has in and the experience that they've had in enforcement, that the one thing they're going to do is tighten up the rules for enrollment. And this is something that's been long overdue. I mean, we would see these cases where Medicare has been paying some fraudulent provider for years until they catch up with them. And we think that one of the ways that they will act to address this concern is to tighten up the enrollment process, which is good in a lot of ways, but will also affect legitimate providers in a manner that we think will could result in making it more difficult to enroll in federal healthcare programs and make getting paid more difficult.
Yeah, I think it's going to slow down the payment process generally as they put in more curbs and gutters to be able to detect potential fraud. But Henry's point about the enrollment process is an important one because for a long time, they've treated things like home health agencies and durable medical equipment companies as so-called high-risk providers that have to jump through a lot of hoops in order to enroll. Notwithstanding that, there's allegations there could be hundreds of billions of dollars in fraud going to organizations that don't even provide services, but are just set up and somehow are able to bill and collect. So I think that across the board, you're likely to see within the next year a big slowdown on how fast they enroll providers. That's going to affect, as Henry said, legitimate providers. Say you're a hospital that goes into an affiliation with another healthcare system and you file an 855A form to say, hey, we have a new parent company. It could be that they slow things down and maybe even stop payment until they process that. They haven't announced that yet, but that's sort of our crystal ball gazing about what might happen in the future.
And worse, what we're seeing, especially with physician practices, is that the government, especially the Medicare program, is taking back money, or at least trying to take back money that they have already paid, oftentimes alleging that the reason for the claim was medically unnecessary, and then you have to jump through a lot of hoops to show that what you did was legitimate, and with the threat that they could try to recoup hundreds of thousands of dollars from you. So I think that it's important to keep in mind that when you build a government, you're not, and you get paid, that doesn't mean you can necessarily keep that money, and you want to have a clearly documented record as to what you did and why you're entitled to the reimbursement that you're claiming is due.
And speaking of recovering money, Henry, they were pretty successful last year in terms of recovering money under the False Claims Act, and in particular in QI/TAM suits, right?
Yeah, I mean, the OIG issued their semi-annual report, and in there they give a nice summary of the success that they've had in the past year. And they touted that they've received 5.7 billion, that's with a B, in recoveries just in the fiscal year 2025. They've had 458 new qui tam suits, a lot of small and medium settlements, not one or two. And then there were one or two really big ones, usually involving pharmaceutical companies. But we think that this trend is only going to get worse, especially as you see federal deficits increase, and there's always going to be a food fight for funding in the federal government, and this is a way for CMS to increase their funding by decreasing payments or going after money that they've already paid.
Yeah, like Henry said, traditionally in prior years, you had a couple of big suits where pharma companies pay hundreds of millions of dollars. That didn't happen as much last year. You had a lot of, garden variety suits, garden variety being in the 8-figure range rather than 9-figure range. But that's going to continue. I mean, there were 458 new qui tam suits last year. Those are all going to be coming through the courts as well. But I think that one of the things that we're going to be looking at in terms of False Claims Act enforcement is a continued focus on the Stark Law.
Yeah. In 2021, the Stark regulations were updated, and they made a lot of tweaks to the regulations that made the enforcement of Stark more provider friendly. And so we've seen there's some people, I think, back off of Stark and think that it's not as big of an issue as it has been. And that would be a huge mistake because, again, the government has reported that in 2025, they recovered $31.5 million in recoveries. There were some really big cases and on that have been alleged and that have settled, and a number are in the process. So keep in mind that Stark compliance is as important as it's ever been, and enforcement of the Stark laws, both by qui tam relators and the federal government, has not gone away.
Yeah, I think if you haven't done it lately, it's time to focus on your physician contracts because, as Henry said, there was one settlement, I think it was Community Health System, paid $31.5 million and settled a Stark case where they were alleged to pay excessive compensation. There was a Hudson Valley Hospital paid almost $7 million where they were alleged to have been improperly subsidizing oncology practice. Catholic Health System in Buffalo paid $3.3 million, again, with some questions about whether their relationships with some physician groups were appropriate. So now is the time, if you haven't done it lately, to do a thorough scrub of your physician contracts, not just contracts with independent groups, which have necessarily higher risk because they're not subject to the exception for employment arrangements in the kickback statute, but also your employed doctors. Both in terms of looking at compensation, but we're suggesting to clients you go a lot deeper than that because we're seeing some situations where employed doctors are doing things maybe out of ignorance, maybe because nobody's watching them, that starts generating a lot of bills that later on get scrutinized, denied, and sometimes challenged as not being medically necessary. When you have doctors who have inordinately high compensation rates that get reported on your 990 form to the IRS and to the public, that's going to be a magnet for potential qui tam relators and also just people who want to cause trouble for the organization by going to the authorities and say, there's no way that this guy could have made this much money legitimately, so take a look at him. So some of the things we're doing with our clients is coming up with some specific guardrails where you make sure that claims are appropriate before they're dropped. Second, another thing that we're telling people they ought to consider is if you're giving somebody RVU-based incentive compensation, that if you later have a claim denied or money taken back, that gets offset against whatever bonus the individual was credited for before that happened. Because otherwise, you're just plowing, as they say in some circles, plowing pig on pork, where you're allowing somebody to basically benefit at your expense for things that later are going to cost you money or possibly trigger enforcement action. So that's an area we're looking at too. But I think, Henry, the issue about the qui tam statute is interesting. There's at least one case still alive where they're challenging the constitutionality of that statute, whether relators can be sort of junior woodchuck attorneys general and file lawsuits to try to recover money under the False Claims Act.
Thanks, Dan. You're right. First of all, and it's always important to keep in mind that Stark is a strict liability statute. If it applies, and it's going to apply in every hospital physician employment arrangement, either directly or indirectly, you want to make sure you fit within an exception. And there are people watching, and one of the areas that the government has relied on for enforcement of the Stark law is the qui tam provisions, which allow private individuals to act as private attorney generals and bring these suits on behalf of the federal government. The government has the right to intervene, and they will do so in certain cases, but a lot of times they just leave it to the qui tam relator, and then the relator gets a percentage of the recovery from the government, which from the ultimate resolution, which can be in the millions. There's been a lot of attacks on the qui tam provision, and the argument being that it violated, that by these individuals acting as attorney generals who have never been appointed through the Article 2 Constitution, Article 2 of the Constitution appointment process, that the qui tam provisions are unconstitutional. Now, a number of cases have looked at that and held that's not true, but Justice
it was Thomas and Barrett and Kavanaugh all had concurring opinions or dissenting opinions in a case a couple of years ago that said they think that there's some validity to this. So you have 3 of the 9 Supreme Court justices who have questioned it. And then there's that case down in Florida. I think it's up in front of the 11th Circuit now.
Right. It's been argued in front of the 11th. There's a case in Florida called Zavrov, in which the court has held that the qui tam provisions are unconstitutional, and that resulted in the qui tam case being dismissed. The case has been argued in front of the 11th Circuit. We do not yet have a resolution or result. We're hoping to have one by the time in the not too distant future, but this is headed to the Supreme Court. And as Dan said, there are 3 Supreme Court justices in the current conservative majority who have already decided that the qui tam provisions are unconstitutional. And so there is a lot of concern that that argument will win the day. So much concern that the Department of Justice has announced that should the qui tam provisions be held unconstitutional, or there be some court decision that would limit the ability of qui tam relators to continue to bring false claims cases to the attention of the government and profit by that the Department of Justice is organizing, and they have a contingency plan for a policy that will allow essentially this, not the same, but very similar to the qui tam provisions that would reward whistleblowers who bring False Claims Act cases to their attention. They're not going to implement that as long as the qui tam provisions are still constitutional, but I think they believe that there's a real chance that the Supreme Court may get rid of the qui tam provisions, which is good for providers. On the other hand, even if that occurs, the Department of Justice will take action to allow private individuals to continue to ferret out fraud, which again is something that you always have to be concerned about.
Yeah, so we're watching these really closely, and Henry and I are going to be in New Orleans on April 9 through 11 doing our program on contracts and compliance. So hopefully by that time we'll have a better understanding of where the 11th Circuit might be going with this case out of Florida. We may have some more information about where the Justice Department is going with this new fraud division. So stay tuned for further developments, but hopefully this compliance update for the beginning of 2026 will be helpful to you.